Welcome, future business leaders, as you embark on your journey to master the intricacies of business management through this MBA course from IGNO. It is essential that you understand the fundamental role that law plays in shaping the business landscape. And in this course on business law that has been tailored for you guys, you IGNO MBA students, we will be delving deeper into the legal framework which governs the business operations, transactions, as well as decision making. Business law is not just about rules or regulations, but it is all about understanding how legal principles intersect with business practices to create a framework suitable for ethical and sustainable commerce. Okay. And throughout this course, we will be exploring a wide range of topics from contract law and intellectual property rights to corporate governance and international trade regulations. So, why is understanding business law crucial for MBA students? Well, imagine yourself as the future entrepreneur. Okay, you're running your own business, or maybe you are corporate executive like a CEO, CFO. Yes, aim big, okay, or maybe you are a business consultant. So, what will happen? You will encounter legal issues, correct? Can you escape from legal issues? No. You will definitely be encountering legal issues at every turn, whether you are negotiating contracts with your suppliers or buyers, or resolving disputes, or navigating the regulatory compliance. So, business law is something that you cannot run away from. And so, if something is inevitable, then let us embrace it, right? So, let us develop a solid foundation in business law so that you will be equipped with the knowledge and skills that are needed to make informed decisions, mitigate risks, and ensure that there is legal compliance in your professional endeavors. If you are new to this channel, then I am Anu. I'll be your guide and facilitator for this course. I run this small but growing YouTube channel named Anu's Classroom, which is aimed at providing IGNO students like you overcome the limitations of distance learning by providing quality content that will not only help you pass your exams with good grades, but also understand concepts well so that you will become better managers. So, are you ready to embark on an exciting journey into the world of business law together with me? Let's start. So, let me provide you with a preview of what awaits us in the following session. This course is divided into 6 blocks and it has a total of 14 units, each of which provide crucial insight into business law. In the first block, that is overview of business law, we will lay the groundwork. The first unit is Introduction to Business Law. Here we will provide an overview of the legal principles and regulations which govern the business operations. In the second unit, Concepts and Principles, we will delve deeper into the fundamental legal concepts and principles that are relevant to businesses. In the second block, that is business forms and legislations, we will explore the different business structures and the laws which govern them. To that extent, Unit 3, the Partnership Act of 1932, we will examine the legal framework for partnerships, whereas in Unit 4, Companies Act 2013, we will cover the regulations governing corporate entities. These two are very important from your examination point of view, so please make sure you understand them properly. In Block 3, Business Contracts, we will focus on principles and regulations governing business agreements. Fifth unit, General Principles of Contract, we will provide an overview of contract law, whereas in Unit 6, International Contracts of Sale, we will explore the legal aspects of international business transactions. Coming to the fourth block, Legal and Regulatory Framework for Financing and Investment of Businesses, we will look at the legal frameworks that surround the business financing and investment. Seventh unit, under Block 4, Banking and Other Allied Regulations, we will cover the banking regulations, whereas in Unit 8, Foreign Exchange Management and Related Regulations, we will address the laws governing foreign exchange transactions. In Unit 9, Insolvency and Bankruptcy, we will explore the legal procedures for handling insolvency and bankruptcy cases. So, this, at least Unit 9 in particular, is a very important unit. Questions have come up from here. So, make sure you go well prepared over here as well. In the fifth and second last block, we have 6 blocks here. So, in the fifth block, Intellectual Property and Data Management, we will examine the legal protections for intellectual property and data. In the 10th unit, we will discuss the various forms of intellectual property protection. And in the 11th unit, we will address laws governing data management and privacy. Again, concepts that you have to be aware of, not just from your examination point of view, but your general as a managerial role point of view as well. So, finally, the sixth block, business and sustainability. We will explore the legal frameworks promoting environmental protection, competition, and consumer rights. In Unit 12, environmental protection and sustainability, we will focus on the environmental laws, whereas in Unit 13, competition law, we will examine regulations that are aimed at promoting fair competition. The last unit of this particular course, Unit 14, is dealing with consumer protection law. So here we will cover the laws that are protecting consumer rights as well as interests. I am thrilled to embark on this journey with you. Are you thrilled? I hope you are. And I am confident that together we will gain a deeper understanding of the legal framework of businesses and be ready to drive success and profitability within our organizations. So before we start, I would like to remind you this is a rapid roundup session. We will be covering all these 14 units. I'll try to give you an idea of what is there, what are the key concepts in all these 14 units. We will not be delving deeper into any particular unit or any particular topic for that matter, because this is an overall coverage in this short span of time. But I'll try my best to give you a maximum knowledge in this particular span of time. Okay, so that is what you can expect from this rapid roundup. If you are new to this channel, I kindly ask you to take a moment and ensure that you have subscribed to the channel and you have enabled the notifications also, because by doing so, you can ensure that you will never miss an update from Anu's classroom. And in this way, you can fully utilize all the resources that I provide to support your journey towards earning your postgraduate degree from IGNOU. Feel free to leave your comments or questions or suggestions below. I'm here to help you out, so don't hesitate to ask anything. Just remember to keep your comments professional, like you would in your future managerial role. That is all the ask is. So whether you're dreaming of starting your own business or you're already knee deep in the world of commerce, that you have already started a business or you are managing something, understanding business law is key to navigating the ups and downs of business. Firstly, let us grasp the fundamental concept of business itself. At its core, business encompasses a diverse array of activities, whether it is pursuit of profit-driven ventures or maybe noble non-profit endeavors that are dedicated to societal welfare. It could be anything, but businesses will have a diverse array of activities. It serves as the backbone of our economic structure, driving innovation, prosperity, and progress. However, within this dynamic landscape, the need for regulation and order becomes imperative, giving rise to the pivotal role of business law. So, what exactly is business law? Well, it's like the rule book for how businesses have to play the game. Every game has rules, right? Every game has rules. Caroms has rules. Chess has rules. Cricket has rules. Can you think of any game where there is no rules? No, right? So business also is like a game. It's a game of life and it also has rules. Where are the rules written down? In business law. So it constitutes this business law. It constitutes a body of legal principles and regulations that have been meticulously crafted to govern the conduct of business affairs. Its scope is vast and multifaceted, encompassing everything from the formation and continuation of businesses to the intricate web of economic transactions. Whether it is the establishment of corporate structures or the enforcement of contractual obligations, business law provides the necessary framework for businesses to function ethically, transparently, and efficiently. Now, why does business law matter? Think of it like this. Without rules, how would a game be? Right? It would be chaos. Similarly, without business law, businesses will also be operating under total chaos. Anybody could do anything, and without any consequences, people will get exploited, cheated. Some people will get better favors. Some people might not get any. There will not be any kind of equality. It is going to be total chaos. Even with business law, we feel it is a chaos, but still, without it, then what extent the chaos would have gone, right? So business law helps keep things running smoothly by providing a framework for resolving disputes and making sure that everyone's rights are protected. So it is like a referee in a game, making sure everyone plays fair and that nobody gets hurt. The objectives of business law are deeply rooted in the principles of justice and fairness. It seeks to ensure the orderly conduct of business affairs while facilitating the resolution of disputes through equitable means. By upholding the rights and obligations of both businesses and individuals, it fosters an environment that is conducive to sustainable growth and harmonious interactions. So, where does this business law come from? Right? So, business law, you can think of it as a recipe for success, or like a recipe to maintain justice and fairness in business. And it comes from various places. So, it has its origins or it has its sources from various places. Like we have our constitution, that is the primary pillar there. We have our constitution that lays down the basic rules and statutes that are passed by lawmakers. We have court cases which have set predicaments in certain specific cases. Then we have customs, the societal customs that have evolved over time, international treaties, government policies. All these things together shape the business law that we see. Each source contributes its unique perspective, shaping the contours of business law and adapting to the evolving needs of our globalized economy. Constitution provides the overarching framework within which business law operates, delineating the powers and limitations of governmental authority. Statutes enacted by legislative bodies codify specific rules and regulations governing the various aspects of business activities. Cases which are decided by courts serve as precedents that guide the interpretation and application of the law in real world scenarios. Customs that are rooted in tradition and societal norms offer valuable insights into prevailing business practices. Treaties which are forged through international agreements harmonize the legal standards across borders, facilitating cross border commerce. Finally, government policies play a pivotal role in shaping business law by promulgating regulations and guidelines that are tailored to specific industries and sectors. Now let us dive into the foundational elements of business law, which is the cornerstone upon which modern commerce is built. First, we must grasp the fundamental concept which underpins business law, that is, contract law. Contract law governs the formation and enforcement of agreements essential for every business transaction. Company law regulates the establishment, operation, and dissolution of companies, ensuring transparency and accountability. Intellectual property law safeguards the fruits of innovation, protecting patents, trademarks, and copyrights. Competition law maintains a level playing field in the marketplace, fostering fair trade practices. Consumer protection law shields consumers from exploitation and ensures product safety. Finally, taxation law dictates the financial obligations businesses owe to the government. These concepts are underpinned by fundamental principles. The principle of freedom of contract affords parties autonomy in their agreements. Limited liability shields shareholders from personal liability for corporate debts. The principle of separate legal and distinct entities from their owners. Corporate governance principles ensure ethical and responsible management practices. Social responsibility mandates that businesses consider their impact on society and the government. In the Indian context, several statutes govern business activities. We have the Indian Contract Act of 1872, way before independence, which lays down the framework for contractual obligations. We have the Companies Act of 2013, which regulates the corporate governance and administration. The Competition Act of 2002 promotes fair competition and prohibits anti-competitive practices. Consumer Protection Act of 2019 safeguards consumer rights and interests. The Foreign Exchange Management Act of 1999 governs foreign exchange transactions. Additionally, the Goods and Services Tax (GST) Act of 2017 provides a unified taxation system for goods and services. Dispute resolution methods are essential in resolving conflicts effectively, and litigation involves the formal legal proceedings before courts. Alternatively, we have alternate dispute resolution methods also. These are called ADRs, alternate dispute resolution methods, such as arbitration, mediation, conciliation, and negotiations, which offer again efficient and often less adversarial means of resolving disputes without having to go to the court and fighting a court case. Partnerships are the dynamic alliances which fuel entrepreneurship and collaboration in the business world. Picture this. Two or more individuals come together, they're joining forces, pooling their resources, their talents, and dreams to create something greater than the sum of its parts, right? Individually, whatever they could have done, more than that, they can do together, right? So, that is the essence of a partnership. But what makes a partnership tick? It's all about some magic ingredients. What is that? A shared agreement on how to divide the profits, a common vision driving the ship forward, power of mutual agency, that is, each partner acting on behalf of the whole. So, now let us break it down. Partnership comes in various flavors, each with its own distinct flavor profile, like each with its own different characteristics. You have got your classic general partnerships where everyone is in it together, sharing both the highs and the lows, profits and the losses. Then there is the limited partnership, which is a blend of general and limited partners offering a mix of shared risk and limited liability. And then there is an enigmatic limited liability partnership, LLP. You have heard, right? You might have heard of both limited as well as LLPs. If you see certain, you look closely when you go outside, you look at the boards of the shops or the business enterprises that you have, small or large, around wherever you are going, you will see some of them have limited with them, some of them you will see LLP written. Okay, so what is this LLP? LLP is nothing but limited liability partnership. So this is also a very important type of partnership. So an LLP is like a separate legal entity with a touch of magic, which you can say, what is that magic is that LLPs shield the partners from the perils of unlimited liability. So you might have heard of cases where businesses go into loss and the personal properties of investors get attached to resolve uh, to get rid of the business losses. So how can we make sure that that does not happen is via limited liability partnerships. It will shield our personal finances or our personal properties from going off because of any business losses that we might encounter. But hold on, like partnerships are not just another name for teamwork. You might feel like that now, right? Because it is all people coming together and working. You might think that it is a kind of teamwork, but no, it is not just another name for teamwork. Partnerships go well beyond that. They stand apart from other business structures like sole proprietorships or corporations and cooperative societies. While sole proprietorships are one person show or a one man show with all the risk on one set of shoulders. When it comes to corporations, they are sleek, they are separate entities offering shareholders the allure of limited liability. Cooperative societies, on the other hand, are like community driven hubs uniting individuals under a common cause. So, now let us come to the legalities of it. How do we formalize partnerships? Right? So, when we have to formalize partnerships, we have to have a formal partnership deed, which is you can think of it as the Bible of partnership agreements, right? So, while it is not mandatory that your partnership has to have a partnership deed, but registering such a document with the registrar of firms is will add an extra layer of armor to your business, and it will guard against any potential legal storms on the horizon. But wait, there is more. Partnerships are like living, breathing entities that are subject to change and evolution, right? So maybe sometimes you will have to welcome new partners into the fold. Maybe you will have to bid farewell to the old comrades that were with you for so long, or maybe you will have to even dissolve the entire partnership altogether. So each transition requires careful navigation of legal waters to ensure that there is a smooth sailing for all people who are involved. Now, let us fast forward to the limited liability partnerships, which has a blend of flexibility, limited liability, as well as tax benefits. So, LLP is like the superhero of business structures, which offers partners a golden ticket to success. And the best part is, forming an LLP is as simple as registering it with the registrar of companies and assembling your dream team of partners. A company isn't just another business entity. It is a legal creation that is born under the auspices of the Companies Act with a distinct personality, perpetual existence, and the power to act as an individual in the eyes of law. That means when you create a company, it becomes, or it will then from then on have all the rights and personality and everything as similar to another individual in the eyes of law. Okay, so and that is because of the Companies Act. So that is why, if you remember, in accounting, while we were creating entries, debit and credit entries, you remember the business entity concept, the going concern concept, and all those things. So the basis of having such things was to keep the company or your enterprise separate from you, right? So even though it is you who has created the company, or you who has, or who is running the company, or anything else, like for example, uh, take Anu's classroom for example, right? I created the channel, but after a while, like when it becomes formalized, Anu's classroom will be treated as a separate thing, different from myself, right? So, and the reason why that is there is because of the Companies Act. So, any company which becomes a legal creation under the Companies Act will have its own different personality and existence beyond the creator, and the power to act as an individual in the eyes of law. So the defining traits of a company becomes limited liability, transferability of shares, perpetual succession, and a separate legal entity, which, and these are the defining traits which lay the groundwork for its operations and interactions within the business landscape. So that is why you must have seen, right, some companies since 1920s, the person who actually founded the company was definitely long gone, but the company is still there. When you talk about the company, you talk about it as a different person itself, right? So that is all because of the Companies Act. Now let us walk through the journey of a company's formation. It all starts with promotion, that is the spark of an idea, the visionaries who conceive it, and the tireless efforts to transform it into reality. So it is what starts the company, like the budding stages, the infancy. Promoters are the architects of this particular journey, navigating the complexities of raising capital, navigating legal frameworks, and laying the foundation for the company's future. Central to the formation process are two key documents, the Memorandum of Association and the Articles of Association. The memorandum outlines the company's fundamental details like the name, objectives, registered office, and capital structure. Meanwhile, Articles of Association is what governs the internal workings of the company, dictating the roles and responsibilities of shareholders, directors, and auditors. Now, let us talk about going public. You must have seen, especially if you read newspapers, definitely, that at times you will see that certain companies are going public, that the IPO is starting, like that you will see, right? So, that is now, earlier, like when the shares will be for the partners alone, but when the companies goes public, then it will start listing their shares in the stock exchanges, BSE or NSE or both, and we can start buying and selling, trading on those shares. That is what we generally understand when we say a company is going public. So what does it mean? A prospectus is a company's invitation to the public which offers a glimpse into the history, management, financial performance, and future aspirations. And this prospectus becomes the cornerstone of transparency, providing potential investors with the insights that are needed to make informed decisions about their investments. So it is looking at this prospectus that potential buyers would decide whether or not to buy the shares of such publicly listed companies. Shares and debentures are the lifeblood of a company's capital structure, and it represents ownership stakes and long-term borrowing. So shares is what represents the ownership stakes, and debentures is the long-term borrowing. Share capital fuels growth and expansion, while debentures offer a source of funds for strategic initiatives. Deposits, on the other hand, represent short-term funds that are raised from the public, further bolstering the company's financial position. At the helm of every company are its directors, who are entrusted with the collective responsibility of steering the ship. The board of directors formulates policies, makes strategic decisions, and ensures compliance with legal and regulatory frameworks, safeguarding the company's interests and fostering its growth. But what happens when the journey of the company comes to an end? Sometimes companies do shut down, right? So, what happens at that time? Winding up is the process of bringing a company's affairs to a close, whether it could be voluntarily or because of an order from the court. Right? And solvent companies bid farewell on their own terms, whereas insolvent ones will undergo court mandated closures. So it is a meticulous process which involves asset realization, debt settlement, and equitable distribution of the remaining assets to shareholders. Okay, so that is about the Companies Act. So I hope you got a general idea of what this unit has. It is a very important unit. Let me remind you once again. Make sure you go studying it thoroughly. So another very important concept that we have to know about when we talk about business is contracts. A contract is a legally binding agreement between two or more parties which creates an obligation that is enforced by law or which is enforceable by law. In simple terms, it is a formal agreement which outlines the rights and responsibilities of each party that is involved in a transaction or an agreement or an arrangement. The essence of contracts lies in their ability to facilitate mutually beneficial agreements, foster trust and predictability in human interactions. And before we can start discussing on contracts, let us explore mercantile law a little bit. Mercantile law is also known as commercial law or business law. It is a specialized branch of law which governs commercial transactions and the operations of businesses and corporations. It encompasses a wide range of legal principles, rules, and regulations which regulate the conduct of commerce and trade. Mercantile law plays a fundamental role in contracts because it provides the legal framework within which commercial transactions and agreements are formed, executed, and enforced. Okay? Why we are learning about mercantile law, why it is important that you learn about mercantile law is because it is within this framework of mercantile law that commercial transactions or agreements can be formed, executed, as well as enforced. So three important things. The source of mercantile law, if you have to talk about the sources of mercantile law, we have the ancient law of merchant or the lex mercatoria, which has its roots in the customs and practices of merchants. Then we have various acts of parliament or statutes which provide legislative frameworks and regulate commercial activities. There is the common law of England with its rich history of judicial precedent, which shapes the legal principles that are applicable to commerce. And definitely, let's not forget the equitable principles which guide fair and just outcomes in commercial disputes. So there are a lot of various sources of mercantile law. Now let us dive into the formation of contracts, which is the cornerstone of commercial interactions. So at its core, the formation of a contract involves three key elements: offer, acceptance, and consideration. The offer or the party making the offer extends a proposal to the offeree. Okay, so the offerer is the party making the offer. The offerer extends the proposal to the offeree, to whom the offer is being made. The offeree will then accept it with consideration. Something of value is exchanged between this offerer and the offeree. So this mutual agreement, once is communicated, will bind both the offerer and the offeree, both these parties, to the terms of the contract. So that is how a contract is formed. But what makes a contract legally enforceable? Right? We said that a contract is legally enforceable. How? How is it? Several essential elements must be present in the contract to make sure that the contract is legally enforceable. Okay, so consideration, the exchange of value ensures that both parties are giving something in return. Capacity to contract ensures that parties are legally competent to enter into agreements. Like for example, minors or those who are mentally incapacitated may lack this capacity. So if you enter into a contract with a minor, it is not legally enforceable. Free consent is vital, meaning that parties must agree to the contract without coercion, undue influence, or misrepresentation. Finally, the object and consideration of the contract must be lawful. Contracts with legal purposes or considerations will be void. Once a contract is formed, parties are now obligated to perform their duties as outlined in the agreement. However, breaches can occur when one party fails to fulfill their obligations. So what are the consequences of breach? The consequences of such breach could include damages, specific performance, or injunctions, depending upon the circumstances and the remedies that are sought for such fails. Okay, so understanding these general principles of contracts will provide a solid foundation for navigating the complexities of business dealings. So it is again very important. So business law, I know, is could be a little bit difficult, especially for people who are not familiar with this commerce or kind of topics. But believe me, it is a very good read, and it is very, very important also for you guys to have a general basic understanding of these things, whether you are trying to enter into a business yourself or whether you are trying to get into a managerial position, especially as a manager, because you will be given a lot of responsibilities. You need to know about the legalities. Now, to help you understand the contracts for international sale of goods, that is CISG, I want you to picture a bustling marketplace where goods from different corners of the world seamlessly find their way into the hands of eager buyers. Have you heard about the global village which happens every year in Dubai? Maybe you can picture that as well. Okay. So, but just picture this. There are goods from every corner of the world that is there, and there are people who are willing to buy it. So, in such a situation, let us try to understand the contracts that would be in place for the international sale of goods. So, what makes this intricate dance, you can say, of trade possible, right? There are people from all over the world who are ready to buy as well as sell. How does such a thing become possible in the first instance itself? So, this is because of CISG, that is because of the contracts for international sale of goods. It is nothing but a set of rules which serves as the guiding light for international transactions, forging a path of clarity and reliability amidst the complexities of cross-border trade. So, CISG, that is contracts for international sale of goods. CISG, it is not just any set of rules, but rather it is a uniform framework that is meticulously crafted to govern the sale of goods between parties from different countries. Imagine a world where businesses from diverse cultural backgrounds and legal systems can come together under a common set of rules. That will be more easier, right? So that is the essence of this CISG. By providing a standardized approach to the formation, performance, and breach of contracts, the CISG fosters a sense of trust and certainty in our international transactions. So it is like the glue which holds the global marketplace together, reducing the risk of disputes and misunderstandings between parties. Now let us try to take a journey back in time to uncover the fascinating historical roots of this CISG. Now CISG is there in place, so definitely it must have some history as to why it came into being, right? We have some practices which when we try to apply in certain situations won't work, and that is when we come up with some other practices, right? So what is the reason why the CISG came? What is the historical root of the CISG? Let us try to find out in brief. Okay. So it all began in the early 20th century when visionary minds like Ernst Rabel dared to imagine a world where international trade could be governed by a unified set of rules. And despite the tumultuous events of history, including the upheaval of the Second World War, this dream of a global village persisted. And in 1980, the United Nations Convention on Contracts for the International Sale of Goods was born, ushering a new era of harmonized trade regulations on the global stage. But how do these rules come into play in the real world scenario? The applicable law and rules for international sale of goods can be determined by the parties themselves or by the law of the country where the contract is performed. So in some cases, the international treaties provide the legal framework for governing certain contracts. Either the United Nations Commission on International Trade Law, which has created the treaties, including the CISG, can provide substantiative contract rules for cross-border transactions. And let's not forget about the model contracts and clauses, which are the building blocks of this international trade agreements. From international sale contracts to distribution agreements, these meticulously crafted documents, these model contracts and clauses, provide a roadmap for parties to navigate the intricacies of global commerce. These are written with precision and with clarity and ensures that the terms of agreement are crystal clear, leaving no room for ambiguity or misunderstanding. So in conclusion, the CISG and its accompanying framework of model contracts and clauses, they serve as the cornerstone of international trade, fostering trust, reliability, and confidence in the global marketplace. And as we continue to navigate this ever-changing landscape of international commerce, let us remember the guiding principle of CISG, that is unity, clarity, and cooperation. The reason why CISG is there is to make sure there is unity, there is clarity, and there is cooperation, and these are the three basic things which propel us forward on the path of prosperity in today's ever interconnected world. So regulations, as you all must now be understanding, is the bedrock of stability in any financial system or in any system, right? And the banking landscape, that is a very dynamic landscape. So these regulations become very important. So let us explore the journey of banking regulations, especially in India, and the intricate interplay with other laws. Shall we? So I want you guys to take your mind way back into 1949, just after independence, when the Banking Regulation Act emerged as a beacon of change, placing our Reserve Bank of India at the helm of banking supervision and regulation in India. This pivotal legislation is what bestowed RBI with the power to oversee banks, ensuring their soundness and resilience in the face of economic flux. Economic flux means economic changes. But obtaining a bank license is no walk in the park, let me tell you. Banks have to meet a slew of stringent criteria, including minimum capital requirements, reserve maintenance, and adherence to fit and proper criteria for their directors and management. Additionally, a sound business plan and compliance with RBI guidelines on branch location and service offerings are non-negotiable. Yet, the Banking Regulation Act does not stand alone. It is entwined with a web of other laws. Picture the RBI wielding its regulatory powers in the money market under the RBI Act, and it is steering the payment and settlement systems under the Payment and Settlement Systems Act. And it is navigating the flow of capital in foreign exchange market under the Foreign Exchange Management Act. So that is why I said it is not just the Banking Regulation Act alone, but rather it is a complex web of multiple acts and regulatory practices. Moreover, its reach extends to the corporate governance, securities, and insolvency laws also. So they all come together, knitting together a very comprehensive regulatory framework. And yeah, let's not forget the silent orchestrator behind this scene. What is that? Who is that? The central government, right? So the central government is what holds the reins of this banking regulation, overseeing the RBI's regulatory mandate and wielding substantial influence over the public sector. From appointing the RBI governor and deputy governors to issuing directives on matters of public interest, the central government's role becomes pivotal in maintaining the integrity of our banking sector. So, in essence, banking regulation is not just about rules and oversight, but rather it is about safeguarding the heart of our financial system. It is about fortifying the banks against any kind of financial storms, ensuring that they are resilient in times of turmoil. So times of turmoil is definitely in times of global depression, in times of inflation, such things. Financial turmoil is what we are talking about, and ultimately fostering trust and stability in the economy. So as we navigate the complexities of banking regulation, let us remember its profound impact on the financial landscape and the resilience that it imbibes in our banking institutions. So we said that the banking regulation doesn't stand alone. If when it comes to the international exchanges, there is FEMA. So let us now try to understand about the foreign exchange management and the related regulations that accompany it. Foreign exchange, as you must now be aware, becomes the lifeblood of international trade and commerce. It forms the cornerstone of the global economic transactions. In India, the regulatory framework that governs this crucial aspect is none other than the Foreign Exchange Management Act, FEMA, which is a robust regulation. It's a robust legislation that has been crafted by our central government. So now let us try to understand the intricacies of FEMA and its profound impact on the management of foreign exchange in our country. FEMA, with its noble objectives, stands as a sentinel that is guarding the integrity of India's foreign exchange market. What is its mission? Its mission is to facilitate a seamless external trade and payments, nurture an orderly development of our own foreign exchange market, and prudently conserve our precious foreign reserves. But we have to tread carefully. Why? Because FEMA also lays down the law on what is permissible and what is not permissible when it comes to international foreign exchanges. Prohibited transactions like unauthorized possession or transfer of foreign exchange or foreign securities or any kind of immovable property that is located beyond our shores will come with hefty penalties and fines for the people who are violating such the acts of FEMA, the rules of FEMA. So compliance is not just an option, but rather it is the cornerstone of responsible conduct in the realm of foreign exchange management. And who holds the reins of authority in this regulatory arena? We said when it comes to banking and finance, the banking regulations, it was the central government. Who holds the reins when it comes to FEMA? It is the Reserve Bank of India. Reserve Bank of India, our stalwart guardian of monetary stability, is the one or is the authority for regulating FEMA. So with FEMA as its guiding compass, the RBI assumes a pivotal role in steering the ship of foreign exchange management, overseeing enforcements, penalties, adjudication and appeals with a firm hand. But let's not get lost in the legal labyrinth here. FEMA has 7 chapters and 49 sections. Okay. Just to give you a quick idea about FEMA, it has 7 chapters, 49 sections, and with these 7 chapters and 49 sections in FEMA, it delineates the landscape of foreign exchange management in India with precision and clarity. So it draws a line in the sand between residents of India and non-residents, the capital account transactions and the current account transactions, each governed by their own set of regulations. So in essence, FEMA is not just another piece of legislation, but rather it has become the backbone of our nation's foreign exchange management regime. It safeguards our economic interests, it fosters transparency as well as accountability, and it ensures the smooth functioning of our global financial interactions. And as we navigate this ever-evolving landscape of international trade, let us also do our best when we are working as managers, when we are leading a business. Let us also do our best to uphold the principles that are enshrined in FEMA. That is, promoting economic growth, preserving stability, and advancing India's interests on the global stage. A very important concept for us to know about: insolvency and bankruptcy. So in India, the journey towards a more efficient and effective insolvency regime was actually marked by a pivotal moment. That is the enactment of the Insolvency and Bankruptcy Code, IBC. It is extremely important that you know about this IBC, and this happened in 2016. But before we delve into this transformative power that this IBC has, let us rewind the clock a little bit and explore the landscape of insolvency law in India pre this IBC, that is pre 2016. So picture a maze of laws and forums with each that is grappling with insolvency and bankruptcy in its own way. Okay, so we had the Presidency Towns Insolvency Act in 1909, that is when the British was ruling. Then the Provincial Insolvency Act came into being in 1920. Then the Sikh Industrial Companies Special Provisions Act came up in 1985, that was post-independence. So the landscape of bankruptcy and insolvency laws was actually a very fragmented one, with a lot of laws and regulations and different things, and also there are a lot of delays and there are a lot of complexities. So all these things was, you can say it was screaming, our law was actually screaming to get a unified solution for companies that would be dealing with insolvency or bankruptcy. So that is why the Insolvency and Bankruptcy Code came into being, and it is like a beacon of hope amidst all the chaos and all the various conflicting laws here and there. So it was enacted in 2016. The Insolvency and Bankruptcy Code actually heralds a new era for insolvency resolution in India. At its core lies a comprehensive framework which consolidates all the laws relating to insolvency across all kinds of entities, whether it be companies, limited liability entities, or unlimited liability partnerships, or individuals, whatever it is. Whatever laws were there related to insolvency and bankruptcy, it consolidated all of them into a single heading. Now let us unpack the essence of corporate insolvency under our IBC. So this is again a journey that has been marked by distinct phases, like from the initiation of the corporate insolvency resolution process to the appointment of an interim resolution professional, the constitution of a committee of creditors, and the meticulous crafting and approval of a resolution plan. So finally, the culmination is the implementation of the resolution plan, breathing new life into financially distressed entities. So the thing is that when a financial entity understands that there is an issue, right, that there is a requirement for insolvency, we might be heading on to bankruptcy, what happens is that first they submit insolvency resolution process. And what happens then is that a person will be appointed, a professional that is, who would help find a solution on how best we can go ahead to get what you can say, overcome the bankruptcy, or how best we can go about this insolvency. And also, so they will do the analysis and they will come up with ideas. Then they will talk to the creditors of the particular business entity. They will talk with them, speak with them that these are the potential possibilities, and the professional, the insolvency resolution professional, the interim resolution professional, and the creditors, they meet and they come to a consensus on what has to be done. And that is how the crafting, and that is the phase where the crafting and approval of a resolution plan happens. Once the plan is in place, once we have a plan, then we implement the resolution plan. And once the resolution plan is implemented, a new life or a new phase will start for the particular financially distressed entity. So that is how companies or such financial entities it works. What about an individual's bankruptcy, right? What if I go bankrupt? Even then, IBC has a provision for that. So part 3 of the code of this code, this insolvency and bankruptcy code, the part 3 of this particular code delineates the process from the initiation of bankruptcy application to the appointment of, again, a bankruptcy trustee and the realization of the debtor's assets for equitable distribution among creditors. So there is this Malayalam movie which you have seen when I was a kid. If anybody of you listening to me is Malayali, then they might have also seen. So earlier when I was young, we used to watch all these movies, most of the movies in Asianet. That was the most popular channel. So there is this movie called, I believe the name is Rajatandra, where Innocent, he's again a famous actor in Malayalam. So Innocent is playing the role of a businessman. And I don't remember what was the reason, but for some reason because he doesn't want to lose, his business was failing or something, and he doesn't want to pay off the debts with his personal wealth. So he files for this bankruptcy, and a person, an ombudsman, is appointed to look into whether he's actually saying the truth or not before granting that this person has become a pauper. Right, so it is a very good watch. If you guys haven't watched it, maybe when you get time, not now because your term and examinations are near, but if your term and if you have sufficient time, then definitely do watch it. Maybe since after this studying about this business law, now when you watch it, maybe you will understand a little bit more about what that person is trying to do, the cunningness that businessmen employ and such things, and how the law was at that time. So similar to that, even in other languages also there might be movies. So movies are a good source to learn, especially when it comes to MBA. Like, there are a lot of things which are showcased in movies, becomes a very good resource for us. So now onwards, like when you watch a movie, you look at it from an MBA perspective, you will learn a lot of things. You will see a lot of things that you have learned being put into action. Yeah, so that is one thing about bankruptcy. Then now let us also touch about the liquidation of insolvent companies, which is again a critical facet of this insolvency landscape. So in part 2 of the insolvency bankruptcy code, there is a course of action that has been charted in order to do which guides us on how insolvent companies have to be liquidated. So again, the process starts with initiation of the liquidation process to appointment of a liquidator, and later the realization of the company's assets and a judicious distribution of proceeds among the creditors. But the IPC is not, you must understand, it is not just a piece of legislation, but rather a paradigm shift. It is about more than just laws. It is about creating a robust institutional infrastructure that can support the insolvency and bankruptcy process. There are 4 pillars of this: the Insolvency and Bankruptcy Board of India, then the National Company Law Tribunal, the National Company Law Appellate Tribunal, and the Insolvency Professional Agencies. So there are these 4 pillars of this IBC. And each of these pillars, they play a pivotal role in shaping the future of insolvency resolution in India. With this IBC, actually, the process of insolvency and bankruptcy regulations have become much more faster than it was before this law. That is a given. But definitely there is still more scope for progress. Intellectual property, IP. It is the bedrock of our innovation. It is the cornerstone of creativity. It is the guardian of human ingenuity, I must say. So, what is this IP? I've said a lot of things in a very short span of time. Bedrock of innovation, cornerstone of creativity. What is this fancy words? What is this IP? Right? Why is it so crucial? Okay. So, in order to understand what exactly IP is and why is it so crucial in today's world, let us first imagine the world, or let us try to picture the world. Let us rewind our clocks and try to picture a world which did not have intellectual property rights. Okay, a world where ideas were free for the taking, where creativity went unrewarded. Tesla, very classic example, right? Everything he made as a scientist, free for use. If anybody else was taking his ideas and working upon them and enhancing it, all right, fine, do it. It was a world without intellectual properties, right? The creativity was unrewarded. Innovation might have stagnated a lot at that time, right? So, intellectual property, in essence, encompasses the creations of the human mind, whether it is the invention, scientific inventions, or literary works, or artistic works, symbols, or names, or images, whatever it is that is used in commerce. So, it is the intangible essence of human creativity that is protected by law, so that the creators who actually created these things receive the recognition and the financial benefit that they deserve out of their creativity. That is intellectual property. But then why is there a need for protection, you might ask, right? So the answer lies in the very fabric of our human nature. That is the innate drive in us to innovate, to create, to push our boundaries of what is possible. And without intellectual property protection, this drive might be stifled. It could be relegated to the sidelines by a specter of infringement and exploitation. Like, for example, you are doing the things, but your friend is always taking the credit. Now, will you be motivated to do more with the same person? No, right? So, but if your ideas are given credit to you, then you will feel more motivated, right? So that is the basic thing here. And nowadays there are a lot of cases going on because like, for example, Kantara, the movie, so Thaikudam Bridge was there saying that they had used their music in the movie. Similarly, Manumal Boys released, and now there is a court case on why you were used Ilayaraja's composition, Kanmani, that Kanmani Unvita Saukyam Naninga Saukyam, that song, without proper consent from the creator. So like that. And then on top of that, now Vairamuthu came up saying that why are you doing like this? Craft has to be used freely. That is the beauty in it, and things like that, right? So all these things are actually you can link all these things to intellectual property. So that is why we need intellectual property rights. Why? Because without intellectual property, many people might feel that their creativity is being violated, without giving proper credit to them. So it is a promise of recognition and of reward which fuels the flames of creativity, sadly, these days, inspiring individuals and organizations alike to invest their time, their money, and their effort into bringing these ideas to life. Yet, the benefits of intellectual property protection extend far beyond the realm of individual creators. They ripple through the fabric of society, they foster economic growth and development by incentivizing investment in research and development. They create a level playing field for businesses, allowing them to compete on the basis of innovation and quality rather than simply price. And they safeguard consumer interests, ensuring that products and services meet the standards of quality and authenticity that they deserve. So, what forms does this intellectual property protection take? The array is diverse, it is multifaceted. There are patents for innovators, copyrights for literary and artistic works, trademarks are there for symbols, names, and images that are used in commerce. There are geographical indicators for products with a specific origin, like Assam tea, okay, there is Marayur Sharkara in Kerala, Aramula Kannadi again in Kerala. So these are the things I know of since I am from Kerala. Okay, so similarly, what are the things with the geographical indicators and all in your respective states? Please do comment below so that we all can improve upon our knowledge, right? So the list does not end here. There are a lot of other things also, like there are industrial designs, the plant variety protection is there. If you remember a few years back, Lay's You have all had Lays at least once in your life, yes? Or are you bingo fans, not Lays fans? Bingo fans and Lays fans, let's put down your comments, okay? Let me see what you like. Who wins, bingos or Lays? So Lays had actually gone against the farmers, saying that the potato variety that was to be used exclusively for them were sold to other farmers. Something of that sort. There was a case once. I don't exactly remember what the details was, and unfortunately, I'm in a bit of a time crunch, so I couldn't go and check on the backgrounds. But if any of you know about what the case was, or if you have any links relating to that case, do come put it in the comment section below so that all can go ahead and read through it. Okay. Yeah, so that was because they wanted to protect that plant variety, and they wanted to restrict that plant variety to themselves. So again, this also comes under IP. So there is plant variety protection, but it is a little bit different. I think sale of like commercial selling of this seeds and all is not is prohibited, but for personal use or something like that, it is allowed. So there are like the law is not the same for plant varieties and music or art, or let's say geographically tagged items. So the law is different for different items depending upon the nature of the particular item in question, but there is law. So protection of layout designs of integrated circuits is there. So trade secrets, all these things play a crucial role in safeguarding the fruits of human creativity. The right to privacy is a fundamental pillar of individual freedom and dignity, right? Do you like your mobile phone number to be leaked to spam callers? No. I myself have asked, like, from where you have got my number. I haven't signed up for this. Where you have got my number, right? Because my phone number is my personal thing. I share it with someone is one thing, and just I share it for some authentication, or maybe I signed up for something else and they selling it to a third party who might sell it to someone else, and finally reaching the hands of a spammer is something else. That becomes a violation of my rights, right? So the right to privacy is always a fundamental pillar of individual freedom and dignity, which is etched into the very fabric of our democratic ethos. In India, this right has evolved over time and has been sculpted by the steady hands of judicial wisdom and the relentless march of technological progress. But why is it so crucial? Right? At its core, the right to privacy is like a shield to us. It protects the sanctity of our personal information from unwarranted intrusion and unauthorized disclosure. It is a testament to our inherent worth as individuals, affirming our right to autonomy and self determination in an increasingly interconnected world. And yet, as our lives become ever more entwined with the digital realm, the need to safeguard this right has never been more pressing. So, that is why the Information Technology Act of 2000 came into being. It is a pioneering piece of legislation which laid the groundwork for data protection in India. The section 43A of this particular act in particular stands as the bulwark against the tide of data breaches, offering recourse to individuals whose personal information could fall prey to negligence or maleficence. But as the digital landscape is evolving, so too must our laws also. So the state of data protection in India is actually undergoing a transformation, and this transformation is spurred by landmark developments such as the Justice Sri Krishna Committee report and the Personal Data Protection Bill of 2018. And now with the Personal Data Protection Bill of 2019, which is poised for consideration, the stage is again set for a new chapter in our journey towards privacy rights. So what does this Data Protection Bill of 2019 entail, you may wonder, right? So at its heart lies a commitment to empowering individuals with greater control over their personal data, from explicit consent requirements for data collection to the right to access, correct, and even erase one's own data. So now you know, right? Now if you go and look at Play Store, okay, you will see that what is the data that is being collected, whether your data will be used for something else, whether you can ask the app owner to delete your personal data. All these things are disclosed, right? So that is all because of our Data Protection Bill of 2019. So the reason why there is, so now currently, since our book was actually published, I think in around 2021 or 2020, around that time, so that is why the Data Protection Bill of 2019 is told, as of now, the Data Protection Bill of 2019 has been withdrawn, and the Digital Personal Protection Data Protection Act of 2023 was passed by the Parliament of India, and it has received the assent of the President of India also, making the country's data protection legislation. So right now whatever we are seeing is because of the Digital Personal Data Protection Act of 2023. The bill has been withdrawn. Okay, so that is just an update for you guys, because our currently we are in 2024, and our book was published like 2-3 years back. So I want you guys to have the latest information as much as possible. So anyway, since our textbook is talking about Data Protection Bill of 2019, let us try to understand about that, right? So yeah, so that was the Data Protection Bill of 2019. So all in all, what you must understand is that our country has been taking robust measures, steps to ensure that our data, digital data especially, is protected from malicious intents, right? So that was about the data protection and privacy. Now let us talk about the environmental protection and sustainability. So imagine you're standing at the foothills of Himalayas. Have you ever been to Himalayas? Or any mountain range for that matter? Yes, no? Let me know in the comment section below. I myself has not been to Himalayas. I've just seen the pictures, but I really would love to go there one day. So imagine, let us all imagine. Those of you who have gone, then it will be easier for you. But for those of us like me who haven't gone, let us try to picture how it would be standing at the foothills of Himalaya, surrounded by lush greenery and pristine rivers like mirrors, right? That awe-inspiring vista. Oh my God, just a stroke of luck, right? Is it? It is not just a stroke of luck, but rather it is a testament to the constitutional commitment of environmental protection. Otherwise, all industries would have polluted it just the way we polluted all our other rivers, all our other landscapes, right? But the reason why we are able to at least hold it this much, you should also consider the population of India, the space that we have, the kind of developments that are going on. It is very easy for us to compare ourselves with some other country and see why, if they are doing it, why can't we? But you must understand that doing anything in India with such a big population will happen only if each of us strive forward to make it happen. If we leave it in the shoulders of the government, you must understand this is a democracy, and government is not, even your father and mother cannot make you do things, right? Only you can make yourself do something. So maybe they can put you in jail, but that's the best they can. They cannot change your mindset. The mindset has to be changed from within. So it is very difficult for any government, whether it be Modi or whether it be Gandhi or whether it be anybody else. It's not easy to change the mindset of these many billions of people. If it has to change, it has to change from within, from each of us, right? But what we can do best is, now that we have the means, is try to do our best. From the government's perspective, it is via laws only. So anyway, so there are through this unit, what we will be trying to learn is the environmental protection laws, the constitutional commitment that our Indian constitution has, the government of India has, for the protection of our environment. And the second part of that is that we try to abide by it. We try to understand and go by it, understanding that this nature is for us, and without the nature we cannot survive, right? So accordingly, use our common sense, and whether or not it is stipulated by law, if it is not good for the environment, don't do it. If we all do that, if we all can abide by it, then yes, our country can become more beautiful than any other country. With the kind of creativity, with the kind of skill that our people have, it is possible. So anyways, let us come to what are the things in our constitution for environmental protection. So the pivotal amendments of 1976 is what introduced the Article 48A and Article 51G into the Indian constitution, and this has bestowed upon both the state as well as the citizens a solemn duty, that is, not just to protect but also improve our environment. Now, venturing beyond our national borders, we also have global treaties like the Paris Agreement and the Kyoto Protocol, which serves as catalysts for collective action, urging nations and industries to adopt sustainable practices and mitigate the impacts of climate change. Closer to home, the three most important acts, not three, there are four most important acts that we have to learn as part of this particular chapter is the Water Act of 1974, the Air Act of 1981, and the Environmental Act of 1986, and the Forest Act of 1980. each a cornerstone in our fight against pollution as well as degradation. These laws are not only have not only set stringent standards for pollution control, but also established regulatory bodies that are tasked with ensuring compliance and meting out penalties for transgressions. In parallel, we must also recognize the vital role that micro, small, and medium enterprises have or play in our economy. Through initiatives like the Prime Minister's Employment Generation Program and the Credit Guarantee Fund scheme, these enterprises are not only driving economic growth but are also able to embrace sustainable practices. So, in a nutshell, these concepts weave together to form the fabric of our environmental landscape, from constitutional mandates to global collaborations, from legislative safeguards to economic incentives. Each thread plays a vital role in shaping a future where humans and nature can thrive in harmony. So, what I want you to understand, what I want you to keep in mind is that the laws are there. The laws are there. Okay, we have to do it. We have to abide by the law. Only then we are going to see some change in our environment. Sometimes, because in order to do that, sometimes in order to make sure the environment is not harmed because of our actions, we might have to take certain choices. We might have to go with uh, taking a bag and going to the shop, or maybe switch packaged foods to something else, some things like that. For we might also have to adjust, because if we are just going by our convenience and not caring about the environment that we thrive in, then definitely depression and all sorts of diseases and everything is bound to come, right? So, competition law. Competition is there, right? Can you think of anything where there is no competition? No, competition is there. So, naturally, there has to be a law for regulating that competition. So, competition law is like the referee in the game of our businesses. It is there to make sure that everybody plays a fair game and that consumers are also protected. In India, competition law has some big goals. That is to encourage healthy competition, make sure consumers get a fair deal, and keep the marketplace open for everyone. Back in the day, we had the Monopolies and Restrictive Trade Practices Act, or the MRTP Act. It was aimed to stop big companies from taking over everything and stopping competition, but then it had its flaws. So in 2002, we got a new player. We got rid of this MRTP Act and we brought in the Competition Act. This new law is like a supercharged version of this MRTP Act, which is designed to keep the competition alive and kicking. Under this Competition Act, businesses can't team up to fix prices or share markets. That is a big no-no. Also, if a company becomes too big and starts throwing its weight around, then the law will step in to keep things fair. So, who is keeping an eye on all this? We have the Competition Commission of India, or CCI, which is leading the charge. They have a team of investigators that is led by the Director General, who looks into any shady business practices. And if anyone does not like the decisions that are made, then definitely they can take it up with the Competition Appellate Tribunal. So, in a nutshell, competition law in India is all about keeping the playing field level, making sure consumers get a fair shake, and ensuring that everyone plays by the rules. So, it is the guardian of fair competition in our marketplace. Consumer protection in India has come a long way since the days of the Consumer Protection Act of 1986. That law was a game changer, which aimed to safeguard consumer interests and establish mechanism for resolving consumer disputes. Fast forward to 2019, that is when our book was made, and we have got a new and improved version, that is the Consumer Protection Act of 2019. Now, under this act, we have got a whole lineup of consumer authorities that are ready to step in if you have got a bone to pick with a seller or a service provider. There are a lot of cases nowadays, like right in social media also I've seen a lot of cases where people actually fight for their rights as consumers, and they do get the refunds and the whatever losses that they had to suffer, what you can say, settled by the companies. That is all possible because of this Consumer Protection Act. So now under this act, we have got a whole lineup of consumer authorities who are ready to step in if you have got some issue with any seller or any service provider. So we have got the Consumer Protection Council, the Central Consumer Protection Authority, then the Consumer Disputes Redressal Commission, the mediation cells and things like that. So don't worry. All these authorities, they'll never take away your right to go to court also if things get really sticky. But if before going to court, we have all these various authorities who are there to help you, and if it doesn't work out anywhere, definitely you can go to court. You can take the matter to court. So now let us talk about the CCPA, Consumer Protection Council. Okay, so it is the authority. You can say you can think of the CCPA as the superhero of consumer rights. The CCPA, the Consumer Protection Council, they have the power to investigate, recall products, and even slap penalties on anyone who tries to pull a fast one on customers. So, if you have been duped by any kind of false advertising or any unfair trade practices, then CCPA is here to save the day. Filing a complaint under the Consumer Protection Act of 2019 is also a very pretty straightforward thing. You just need to submit a written complaint along with any supporting documents that you may have to the relevant consumer authority. What they will do is they will review your case and give the opposite party also a chance to respond, and then it is up to the authority to decide who is in the right. And let's not forget about the e-commerce. With the rise of online shopping, the government saw that there is a need to protect consumers in the digital realm also. So that is where the consumer protection e-commerce rule of 2020 has come into play. So these rules lay down the law for e-commerce platforms, making sure that they are transparent about the sellers, the pricing, as well as the product details. So they have even got guidelines for sustainable production and consumption, showing that consumer protection is not just about getting a fair deal, but also about building a better future for everyone. So, whether you are buying something online or offline, rest assured that consumer protection law in India have got your back. So, from CCPA fighting for your rights to the rules that are keeping e-commerce platforms in check, it is all about making sure that you, customers, get a fair deal every time you open your wallet. So with that, we have covered all the major aspects of business law as was stipulated in MMPC 13 of IGNOU's MBA as per the new syllabus. I hope you got a general idea about what is there in all the 14 units of this particular course. Thank you so much for tuning into Anu's Classroom. I hope that you have subscribed to the channel and enabled the notifications, and I hope that the time that you have spent in this particular video has been worth your time. So let us catch up in the next session. All the very best for your examinations. Thank you so much. Take care. Bye-bye.